Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over a section of the Family Code, Section 3020, that basically goes over custody and visitation of children. The reason why I'm going to go over it is because I'm going to describe a very common, unfortunately it's very common, situation in which, in a domestic violence matter, for example, one parent of the child will use the children as leverage. And the other parent, unfortunately, I think falls for the tactic more often than they really should. So this video hopefully is going to kind of address that situation. So I'll kind of, now that I've built it up, I guess, I will describe the situation for you. So let's say, I'm going to pick on husbands here or dads here for a little bit. So let's say that, mom and dad are married, and let's say that dad is very controlling, for example, and mom starts to realize and says, hey, I want a divorce, I'm done. This is something where I can't stand you treating me this way anymore, for instance. So, dad then turns around and says, well, if you leave me, I'm going to make sure that you never see the kids again. I'm going to take the kids from you. They're never going to know you. Those kids are going to be mine if you dare try to leave me, if you dare try to file for divorce, etc. So in a situation like that, I'm hoping a lot of you can realize that that is not about love. That's not about compassion, empathy, etc. It is purely a power play. Dad, in this situation, moms can do it too. Dad is basically trying to use the children to control mom, to prevent mom from leaving because dad is, jealous, dad is controlling, whatever. So all too often, unfortunately, moms in that scenario that I described fall for it because they say, hey, you hit me, you abuse me, but I love my kids and I don't want to lose my kids. Fine, I'll stay with you even though you abuse me in all these different ways. So that is, it's understandable, I think. No parent wants to lose their kids, but it's completely unnecessary. And the reason why it's unnecessary is because of California Family Code Section 3020. 3020 is basically what everyone calls it. So 3020, I'm going to go ahead and link it down below, but there is a particular section in 3020, I believe it's 3020B, that I want to draw your attention to. And the specific quote is, frequent and continuing contact with both parents. I'll kind of describe what that means. So in a divorce case or in basically any family law case where minor children are involved, the court's job is to look out for the kids. Mom and dad, the court has some obligations to them, but if there's a minor child involved, child under age 18, the court has specific obligations to them to make sure that they grow up in an environment where they have food, shelter, they're free from abuse, etc. It unfortunately is a debatable topic, I guess, whether or not the courts succeed in that, but by law they are supposed to. They do their best, but nothing is perfect, of course. So one kind of guideline, I suppose, or one sort of mandate that they have, that the courts have, is that the courts basically say, okay, it is going to be rebuttably presumed that a child is going to be better off emotionally, physically, mentally, etc., if they have frequent and continuing contact with both parents. That's what 3020 says. It is not absolute that they have it is not absolute that the child must have frequent and continuous contact with both parents. Conversely, it is not a guarantee that every parent must have frequent and continuous contact with every child. There are certain situations in which that does not happen. But I guess a lot of times people in the scenario that I described way at the beginning, where dad is trying to control mom or mom is trying to control dad, I kind of get the impression that a lot of those parents who fall for that tactic don't realize that by law, California gives them an entitlement to their children generally. So the entitlement is going to be frequent and continuous contact with the children. And it's because the courts have the duty to guard the health, safety, welfare of any minor children that are involved in a family law case. So hopefully that made sense. Basically, Family Code Section 3020, it's something where I think a lot of parents, if they knew about it, they would not nearly be as afraid or as vulnerable, as susceptible, I guess, to the threat that, if you don't do what I say, I'm going to take the kids from you. Taking the kids, it's not impossible. It can be done. It generally is not going to be nearly as easy as the parent who's making that threat will kind of think, I guess. Yeah, almost always it is going to be a power play from one parent to the other, where if you don't do what I say, I'm going to take the kids away from you. Section 3020 of the Family Code makes that actually quite difficult. I will say a couple things about 3020. Like I said a moment ago, it is not absolute. There are definitely situations in which, for example, if one parent is a criminal, if one parent commits domestic violence, if one parent is in a gang, or if one parent is on drugs or something, generally, if the parent can't take care of themselves or they're going to be a danger to the children, that is something where the courts are not going to force the children to be with a dangerous parent. If this is a domestic violence situation that, for example, you find yourself in, there's this family. There's a section of the Family Code, rather, that goes over child custody and visitation in domestic violence situations. That's Family Code Section 3044A. I'm going to write that here, actually. So, and link it down below, 3044A. I don't have a video that goes over it right now, but 3044A basically says that if one parent has committed domestic violence, generally the courts are going to assume that it is not a good idea to put the children with that parent. Yeah. And mediators, family court services mediators, for example, will basically kind of default to that also. If you are the parent who is on the flip side, if you're the parent who has, for instance, committed domestic violence and 3044A is being used against you, you should probably take a look at 3044B. That kind of goes over ways in which 3044A can be rebutted. Not a guarantee, it's up to the judge, but 3044A and B kind of address custody and visitation in domestic violence situations. So, yeah. So hopefully all of that made sense. The takeaway here, I think, is because 3020 already says frequent and continuous contact with both parents is going to be presumed to be better off for the children. Taking the kids away, as I've said, I think twice now, taking kids away from one parent is generally going to be pretty tough. One parent generally can't just say, oh, well, I decide that I'm better, the other person's worse, I'm going to take the kids away. Like, it's not that simple, like, at all. So there really should be no reason why one parent should be scared by a threat like that. If there's domestic violence, yeah, okay, well, that's going to be slightly different, of course. Yeah. So on the topic of 3020, I'm going to also go over the 50-50 kind of rumor, I guess, or presumption. Presumption's the wrong word. Like, basically, a lot of times in family court, parents will sort of think, oh, well, the kid, we should have equal custody. We should have the kids 50-50, half the week with me, half the week with you. 3020 does not require 50-50. In other words, frequent and continuous contact, which is what 3020 requires, that can mean 50-50, but that does not have to mean 50-50. So to basically say that 3020 requires 50-50 between the parents is not correct. Some judges will do that, though. It really depends. Some judges will say, oh, well, frequent and continuous means 50-50. That's what I'm going to order. Other judges, I think the majority of judges, will probably not do that. They'll say, okay, well, frequent and continuous basically means, okay, the kids have to see dad every week, and they have to see dad, often, I guess. They can't be just, say, like once a month, let's say. But frequent and continuous could be 25%, 75%. That's possible. It really depends. So 50-50 is not guaranteed. I will also kind of describe to you that 50-50 a lot of times will not happen if there's some practical reason why they can't, or why it can't happen. So the most common one that I run into is geography. So let's say, for instance, that there's a case in California and mom lives in the San Francisco Bay Area with the kids. And dad used to live up here, but he got a job and he moved to Southern California, Los Angeles, let's say. That's probably not going to be something where the kids are going to be flying back and forth from San Francisco or from San Jose or San Francisco or someplace down to, say, Orange County or Los Angeles, airport or something. They're probably not going to be flying that, every week, let's say. Maybe once a month, twice a month. All the more, that kind of logic also applies if, for example, one parent lives with the children on the West Coast and the other parent lives on the East Coast, or they live in the Midwest, let's say. So instead of a 1 hour, say, Southwest flight from San Francisco down to Los Angeles, we're talking about a 3 hour flight from, say, San Francisco to Dallas, or San Francisco to Chicago or something. So geography is a limitation here also, but hopefully I guess there are ways to get around the geography limitation. Skype, is one big way. FaceTime's a big way. A lot of electronic sort of ways are things that judges will actually use quite often if you know to kind of suggest them. But yeah, so hopefully, I guess all of that made sense. The kind of my overriding reason here to bring up or to make this video is to basically teach parents that the threat that the other parent might make to take your kids away generally is not going to be something you should worry about. I think I don't mean to kind of give you false hope here, but I think you should know that 30/20 does actually make that more difficult than the other parent would like to make you think. Yeah. So 30/20 definitely exists. It applies to both parents. So frequent and continuous contact is something that the courts will want to shoot for. Geography, of course, will be a limitation. Work schedule of the parents sometimes can be a limitation also. But if you do have a bona fide reason for not doing frequent and continuous contact, let's say domestic violence, that could be one reason why frequent and continuous is not done. 3044, Family Code Section 3044, is a reason why that would be. And lastly, 50/50 is not something that is guaranteed. Courts will generally like to shoot for close to 50/50 though, but it is not a guarantee. There is no kind of mandate or requirement that 50/50 be done. In my experience, however, judges will try to do that when they can, because it is something that I think they will hopefully realize that it does actually make everybody, it makes the situation more peaceful. Less conflict will arise in the future, less court hearings, etc. Yeah. So anyway, hopefully that helped. Family Code Section 3020, frequent and continuous contact with both parents. That's something that's pretty powerful, actually. Courts, there are a handful of statutes under the Family Code, I think, that family courts generally will sort of view as sacrosanct. They're going to try to, they will follow them, basically. It's so important that they do. 3020 definitely, I think, is one of them. And it is something where just not a lot of people know about it, I think. And a lot of parents, moms especially, I think, will get threatened and bullied for no good reason. So anyway, hopefully that helped. Go ahead and comment, share, subscribe, all that stuff. And I will talk to you guys next time. Thanks.